American nationals have free right to travel, Part 2. We are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its listols and papers for examination on the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business, or to open his doors to investigation, so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom, beyond the protection of his life, liberty, and property. His rights are such as the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are the refusal to incriminate himself, and the immunity of himself and his property from arrest or seizure except under warrant of law. He owes nothing to the public so long as he does not trespass upon their rights. Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises, and holds them subject to the laws of the state and the limitations of its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that the state, having chartered a corporation to make use of certain franchises, could not in exercise of its sovereignty inquire how those franchises had been employed and whether they had been abused, and demand the production of corporate listols and papers for that purpose. Hale v. Hinkle, 201 U.S. 43, 74-75. Corporations engaged in mercantile equity fall under the purview of the state's admiralty jurisdiction, and the public at large must be protected from their activities, as they, the corporations, are engaged in business for profit. Based upon the fundamental ground that the sovereign state has the plenary control of the streets and highways in the exercise of its police power, see police power, infra, may absolutely prohibit the use of the streets as a place for the prosecution of a private business for gain. They all recognize the fundamental distinction between the ordinary right of the citizen to use the streets in the usual way and the use of the streets as a place of business or a main instrumentality of business for private gain. The former is a common right, the latter is an extraordinary use. As to the former, the legislative power is confined to regulation. As to the latter, it is plenary and extends even to absolute prohibition. Since the use of the streets by a common carrier in the prosecution of its business as such is not a right, but a mere license of privilege. Hadfield v. London, 98 Wash 657 L, 168, page 516. It will be necessary to review early cases and legal authority in order to reach a lawfully correct theory dealing with this right or privilege. We will attempt to reach a sound conclusion as to what is a right to use the road and what is a privilege to use the road. Once reaching this determination, we shall then apply those positions to modern case decision. Where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. Miranda v. Arizona, 384 U.S. 436, 491. Continued in Part 3 of this series.